Let's fix one of the biggest misconceptions floating around Texas real estate. The closing date isn't always a hard deadline. Let me tell you why. If you're treating every date in the contract like it's make or break, you might be doing it wrong. Let me tell you why. In Texas, specifically in the TREC promulgated contracts, there's one critical distinction that people almost always miss. If a contract says that time is of the essence, that means that the deadlines are strict. Miss it, you're done. You're in breach. But here's the reality. The TREC contracts only mention time is of the essence for one of the deadlines that's included in the contracts. Go ahead, open up a PDF of the contract and do a little word searchy, and you're going to see that time is of the essence only appears in one section of the contract, and that's for the delivery of the earnest money and the option fee. So what does that mean? That means that every other deadline in the contract is just subject to what we know as the reasonable time standard. Translation, what does that even mean? It means if there's a delay in the closing date because of the lender, title, or repairs, it doesn't automatically terminate the contract if the transaction doesn't close on the closing date listed in the contract. So when someone says that they have to close by a hard date, that's not exactly right. So long as the parties are performing within a reasonable time frame, it could be considered that this standard is meeting the standard outlined in the contract. So if you don't understand that distinction, you may be putting yourself and your clients at risk. If you have any questions about this or any other title-related issues, just give us a call at Majestic Title.